it was just very clear. It's clear the Texas Rangers were like, nah, everything's good, man. Don't worry about it. And I thought, I can't do this anymore. And then Edwin said, suck it up, Buttercup. Harden your heart. We work for the bad guys. He didn't say it exactly like that, but it was like,
I was gonna say. We are the Armed Attorneys. Today we're talking about an exciting case that was just heard in the Supreme Court. They just held oral arguments. And this relates to qualified immunity in justified self-defense. Now, there's a lot of hubbub going on about, hey, could this redefine self-defense cases across the United States? Well, there's a little bit to it, and we have to unpack it. But before we begin, show your support for the Second Amendment by hitting that like button. And so this all started with a case out of Houston.
it did. And I will say the local news reported on this case this morning with the splashy headline that the Supreme Court could change the use of force standard nationwide. So buckle up. So yes, this did come out of Houston. An officer pulled over an individual for not paying his tolls, which we actually know a local lawyer who was arrested for that.
Oh, yeah.
Yep.
HOV.
So it happens to the best of us, I suppose. He did not pay his tolls. Officer pulled him over. During the course of the encounter, the individual who was the suspect reached over to put his car in gear to take off running away from the officer. Officer saw this. Officer engaged by throwing himself sort of on into the vehicle. Car moves. Officer says, oh my gosh, I'm going to die. Car's moving. I'm hanging off a moving car. Shoots and kills the suspect. Now, civil suit from the family follows.
Yeah, and so, if we were looking at a criminal case, we'd look at the justified use of force laws under your state. Everybody's going to be a little bit different. And there is a little bit more uniformity when it comes to what are called Section 1983 claims. These are deprivation of rights claims. And that's where the civil suit comes from. And the big kind of bugaboo with all those, and, we talked to lots of people, and I'm sure maybe you're one of these people who are like, hey, look, cops violated my rights. I want to sue them. Mm-hmm. There's this huge kind of downward pressure on those lawsuits for what we call qualified immunity.
Yes.
And so basically the government has to agree to be sued, and they've kind of created this criteria where, all right, if you check these boxes, we'll allow you to sue us for this. But outside of that, you are so out of luck, Jack. And so really what we're looking at in this specific case in Houston is, hey, look, is this a violation of the Fourth Amendment? And so there's, just to give you a little idea, like here's the standard the court's going to look at. Did the officer violate a constitutional right? That right, was it clearly established at the time of the incident, meaning a reasonable officer would have known the conduct was unlawful under legal precedent? So for generally qualified immunity is going to shield these officers in these use of force cases, in these Section 1983 cases, unless we meet both of those conditions. And so really this hinges on a little bit of reasonableness, but we have a split here with two different standards, and this is where I think the controversy lies.
Yes. So even to back up just a moment, because lots of people have had their rights violated by the police. Lots of you. In fact, we hear from people all the time, like, hey, I was detained and then I wasn't who they thought I was. And so then I got released and I want to sue them. My rights were violated. Were your rights violated? Yeah, absolutely.
Yeah.
Your person should not have been seized. However, it's that second portion that really gets people, which is, it's not written as a malice standard. It's basically a malice standard, right? Because the officer has to know that they're breaking the law by doing what they did to you. So that is almost never found. And frankly, just for those of you who are like, aha, but my case actually has that too. The other thing you need is damages. So like just being temporarily detained when you shouldn't have been, what are your damages, right? So, there's lots of hoops to jump through, but yes. So let's say you have this shooting, you have a death case. There's definite damages. There's definite deprivation of a constitutional right. And we have this issue at play now, which the courts are split on, to get back to Richard's toss off to me there. And that's how we get the United States Supreme Court hearing this case, because the U.S. Supreme Court doesn't hear very many cases.
Yeah, we'll throw the style of the case up now, just so everybody can see it.
Yes, this is Barnes versus Felix. It's, of course, very, very rare. A case gets up to the Supreme Court. They don't hear a heck of a lot of 1983 cases.
No.
But this is the split. We have circuits on one side, and that's going to be the Fifth Circuit, Second Circuit, Fourth Circuit, Eighth Circuit, who say, when you evaluate, because what we're doing is we're cramming in use of force into this qualified immunity standard. We're sort of evaluating it through a different lens than we would if it were a typical criminal use of force case. So what they're saying is when we look at these, we do a moment of threat analysis. So in that one specific moment that the officer had to pull the trigger, was he reasonable in believing that his life was threatened? Which, okay, but we have all these other circuits with a different standard.
Yeah, so we have the 1st, 3rd, 6th, 7th, 9th, 10th, 11th, and DC circuits. They don't use that moment of threat doctrine, and they use, and I would say this is where maybe we will find ourselves. They use a totality of the circumstances. They look at the before, during, and after to judge, what the mindset of the person at the time they used force or deadly force. And so that is kind of what's on the table. What standard are we going to use when looking at police misconduct? Like this instantaneous flash of, hey, what's held at this exact millisecond when, they make that decision to use force or deadly force? Or are we going to look at kind of a little bit bigger of a picture? I'd still call it a snapshot, though.
Oh, yeah, still snapshot.
Still snapshot. We're not looking at, hey, this person's whole career. We're not looking at, all right, what'd they do the day after the incident? It's still a snapshot, but, I think all that might be relevant to the fact finder in determining, hey, did the person act reasonable or not?
Right. And in this specific case, and in many cases, which is why I think this standard is ripe for review by the Supreme Court, the officer did something here that escalated, right? And so what we're looking at is that part of what you should be able to evaluate? And of course, the plaintiffs here say, absolutely. Absolutely. You should be able to look and see the officer brought this to the point of deadly force when it didn't need to be there, when there were other options. And I mean, I will say this standard, although this is for qualified immunity, this is not sort of our general everyday self-defense. This is a standard that would help my clients, right? I mean, it'll help your clients. I mean, it's that one little millisecond in time is always colored by everything around it. Right. And when I have people who shoot other people, I mean, there's a lot of reasons for it leading up to that one, specific moment.
Yeah, but if we look at, hey, all right, if we decide Fifth Circuit got it wrong, we're not going to use this moment of threat doctrine. We're going to look at a totality of the circumstances. How does it impact self-defenders? I would say that this is probably status quo. That moment of threat, you don't see that very often. Now, when we're looking at reasonableness, when evaluating whether a self-defender acted reasonably at the time that they used force or deadly force, typically it's going to be two different things. Subjective reasonableness, what's in the mind of the actor at the time that they used force or deadly force, that's probably closer to moment of threat doctrine. And then we have objective reasonableness, and that's like distances, times, visibility, number of actors, presence of weapons, all these other things. And we kind of put those things together and they act as a check on each other. Let's say you have someone who objectively, look at the physical evidence, the times, distances, presence of weapons, actors, all these other things. They were not in any kind of threat and they hold an unreasonable belief in their mind. Well, guess what? Self-defense claims are not going to prevail. And kind of vice versa. Let's say you have somebody who is not scared, maybe because they have specialized knowledge or something like that. But if you just looked at the objective facts on his face, hey, maybe it would, but this person has specialized knowledge to where they were not in actual fear of death or serious bodily injury. Let's say somebody's breaking into a house, and they shot him, but they actually invited him in. They had that specialized knowledge in their head. Guess what? These things act on checks on each other. And so this kind of totality of the circumstances, I think, really won't upset the apple cart that much. And it's kind of the factors that we already look at.
Right. So what's the end result if the Supreme Court says moment of threat, no good? Because that's what the Fifth Circuit did here. They applied moment of threat, and I think the likely outcome we're going to see is the Supreme Court says, no more moment of threat. We have this nationwide standard now of totality of the circumstances. What happens if the Supreme Court does that? Well, I mean, in an ideal world, it has a trickle-down effect, has an ultimate effect on officer behavior, right? Because, if this is what ends your qualified immunity, you have, I think, more incentive to sort of check your own behavior to the extent that you can, right? I mean, I know these are tense situations.
Right.
There's lots of adrenaline, but you know, there is, I mean, I think there an incentive has been brought to the table to do better.
Right. And it's, you know, I don't like two standards. I like, you know, if we're going to judge the government, we're going to judge government agents. If we're going to judge civilians, all right, let's treat them the same. These people shouldn't, I don't think they should get special treatment, right? But we have, if we are looking at, you know, regular civilian self-defender and saying, hey, guess what? You escalated, you didn't take a reasonable, safe alternative, you when we say provocation, you know, you kind of started this chain of events that leads to a use of force or deadly force. All right, we get to consider all those factors for you, self-defender. You're so out of luck. And then we see law enforcement when they say, what was in your mind in that very millisecond? You know, we have this double standard or different standards, and I don't think that is productive.
No. Oh, there's always going to be a double standard, though. I mean, you know, I mean, I've been out to those scenes a lot of times.
High five and angels.
Yeah, high five and a million angels. Yeah, buddy, you got him. I mean, there was one officer involved shooting in Houston I responded to that almost ended my law career because I left that scene and I called Edwin and I said, I can't do this anymore because the shooting was so unjust and they took the life of a kid who was just driving away from him by shooting him in the back of the neck, and there was no reason for it. And by the time I got there and the other lawyers got there, it was just very clear. It's clear the Texas Rangers were like, no, everything's good, man. Don't worry about it. And I thought, I can't do this anymore. And then Edwin said, suck it up, buttercup. Harden your heart. We work for the bad guys. He didn't say it exactly like that, but it was like, all right, sure enough. So anyway, but no, there's always going to be two standards, but anything we can do to mitigate that is a very good thing. And I hope the Supreme Court gets there.
Yes, but we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please leave us a comment below. What do you think about the moment of threat doctrine? Do you think it's a good thing or a bad thing? Until next time, we're the Armed Attorneys.